Today's topic for discussion is International Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 1984. To introduce the discussion, freedom from torture is an agreed human right issue, as guaranteed under international laws and defined by the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, also known as UNCAT. More than 130 states have ratified the UN Convention. Reports suggest that torture continues to be practiced regularly in up to 100 countries, including countries that are parties to the UN Convention. The idea of UNCAT has a history. The history is of human rights violations, torture, cruelty, and degrading systems of criminal procedures and punishment systems as experienced by humanity throughout the ages. Modern state systems have been often equated with legitimacy, consensus, and democracy, which are to be the basis of human rights and personal dignity. Such premises of the modern states have often remained short of its acclaimed values. The crumbling of the values gets testified when one goes through the histories of human subjection to violence, mainly coming from the states. However, today's discussion is not about human rights records of the states, but more about how such violence has resulted in the emergence of an international system on protecting the rights of people from cruel and degrading treatments. It is this very concern that has given birth to UNCAT in December 10, 1984. The importance to discuss the role of UNCAT comes from the fact that there is a continuing threat to human dignity and rights. For example, according to the UN Special Rapporteur on Torture, there is a regular report on acts of torture from more than 60 countries every year. It is also reported that government-sanctioned torture is committed in more than 130 countries worldwide, as mentioned before. Understanding the definition of torture. Torture is considered to be an intentional infliction of severe pain or suffering for a specific objective. Torture is an instrument used to obtain information or a confession, to punish or to take revenge. It is also used to create terror and fear within a population. Such objective of conducting torture abrogates the identity and freedom of persons. Let us examine what are the forms of torture. Common forms of torture include causing pain or fear to individuals, including physical torture, beating, electric shocks, suffocation, and burns, etc. Common methods of psychological torture include isolation, threats, humiliation, mock executions, sleep deprivation, and witnessing the torture of others, including family members. Rape, molestation, and sexual abuses are also a form of torture generally practiced against both women and men during arrest or imprisonment or during conflicts and situations of civil war. Let us examine why certain forms of punishments are considered degrading. Factually referring to international human rights organizations, their reports have cited 125 countries where individuals have been detained and then tortured or ill-treated According to their findings, up to 35% of refugees from these particular countries have been tortured and 90% have witnessed or been exposed to the effects of torture. According to UNCAT, certain types of punishments are degrading, for it causes intense physical and mental suffering. Such punishments lingers victims' fear, anguish, and inferiority sense, and affects the moral being of persons. UNCAT is aimed at protecting people from lifetime psychological and social displacement. The effects of torture, therefore, can be physical, psychological, and social. In addition to the direct physical effects of torture, victims of torture can suffer from flashbacks or intrusive thoughts, severe anxiety, insomnia, nightmares, depression, memory lapses, sexual dysfunction, and a breakdown in social relations. Now let us examine who are the victims of torture. Victims of torture can include social activists, undergrounds, politicians, journalists, social critics, health activists, human rights activists, people in detention, students and civilians, and even children. The effect of torture is so widespread as the victims' families, friends, and communities are also equally affected. In the case of children, they are forced to witness the torture of their parents, or they may themselves be tortured to torment their parents. Let us now examine UNCAT guidelines in terms of its legal principles. Torture is prohibited under international laws. There are a number of international conventions and treaties which condemn torture and which place a special responsibility on governments and non-state forces to stop torture from taking place. UNCAT is the most important and relevant of all the UN initiatives in this regard. Structurally speaking, it has a committee against torture known as CAT, which was established according to the Article 17 of the UNCAT. It also has a rapporteur who monitors and reports on issues relating to torture. To start with the articles, the Article 1, Clause 1 of the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment is, quote, "Torture means any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted by or at the instigation of a public official on a person for such purposes as obtaining from him or a third person information or confession, punishing him for an act he has committed, or intimidating him or other persons," unquote. Some states have used this provision to argue that legally authorized criminal penalties resulting in physical harm do not constitute torture. Moreover, these states also claim that this wording by its very existence legitimizes the use of the death penalty or corporal punishment. Critics disagree with this, saying that these provisions are without prejudice to other international treaties which safeguard the rights to life and security of persons. According to Article 2 and 4 of UNCAT, there is no justification to the use of torture even in exceptional situations. For example, during a state of war, internal political instability, or any other public emergency, no matter even if there is an order from superior authorities to justify torture. According to Article 3, I quote, "No state party shall expel, return or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture, unquote. We can also refer to Article 5, 6, and 8 for matters regarding the principles of universal jurisdiction, obligation regarding extradition and prosecution of foreign nationals. All the 130 states which have ratified UNCAT are in principle and in practice bound to follow the UN guidelines on torture. However, the reality is far from what is being aimed at. According to the Article 14 of UNCAT, I quote, "Each state party shall ensure in its legal system that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation, including the means for a full rehabilitation as possible," unquote. In addition, the Article 13 and 14 are significant, for it deals with guidelines regarding the restoration of their dignity and reputation and a public acknowledgement of the harm they have suffered. UN overall commitment in prohibiting torture has been enshrined in the Article 7 of the International Covenant on Civil and Political Rights, which says that, I quote, "No one shall be subject without his free consent to medical or scientific experimentation," unquote. The human experiments conducted by the Nazi during the World War II would fall under this category. One of the significant examples of UNCAT intervention can be discussed in the light of Ireland experiences. UNCAT imposes on Ireland legal obligations to provide services for torture survivors in the wake of the prolonged conflicts in Ireland. A 2001 report by Amnesty International highlighted the use of torture by 140 states between 1997 and 2001 and found that every year thousands of perpetrators rape and electrocute other human beings. Amnesty International has been consistently seeking UNCAT responses to these facts of torture. UNCAT has made enormous impact on signatory members in the following ways. Liability of the state has increased. The international criminal prosecution, private individuals and non-state actors are encouraged to be accountable to UNCAT processes. Now we'll examine responses and intervention of UNCAT. Responding to UNCAT guidelines, the International Council on Human Rights Policy, in its meeting in September 1999 at Geneva, raised the issue of making state and non-state armed groups accountable to UNCAT guidelines. The 1999 meeting commissioned an expert to look into issues regarding Northern Ireland conflict. In this context, it can be recalled that since 1969, over 40,000 people injured, and conflict has cost the British and the Northern Irish economy several billion pounds directly as a result of the conflict. From the early 1980s, Human Rights Watch and in 1991, Amnesty International adopted their monitoring role to include abuses perpetrated by the non-governmental entities such as paramilitary groups. The interventions of such organizations have predominantly referred to UNCAT guidelines. However, the challenge comes from a statist argument which says that Northern Ireland question falls within the notion of an internal armed conflict. Interestingly, regardless of this statist structure, Human Rights Watch and Amnesty International has engaged with issues in Northern Ireland more in line with international humanitarian laws such as UNCAT. In the case of South Africa, in South Africa, the Prevention and Combating of Torture of Persons Act 2013 aims to 1. Give effect to South Africa's obligation in terms of the UNCAT obligations. Number 2. Recognize the offense of torture of persons. And third, it prevents and combats the torture of persons within or across the border of South Africa. We will now examine some challenges. There is no exhaustive list of prohibited acts. International law has made it clear that torture is cruel, inhuman, and degrading. However, national amnesty laws may have shielded perpetrators in different countries. UNCAT get complicated when state laws shield torture, denies prisoners from having access to lawyers, doctors, relatives, etc. In many cases where the state officials are involved, information are either made inaccessible to the international community or trials are often tampered with. With regard to the implementation of UNCAT guidelines in the post-conflict societies, which many post-conflict states have set up collective reparation schemes, usually in the form of a compensation fund that have also been available to torture victims. However, such schemes remained mired in problems like who should be entitled to access the fund, issues of human rights violations during the conflict, and how amounts for compensation are to be determined. On the other hand, some states have blatantly resisted UNCAT intervention, such as in the case of Sri Lanka in the wake of Tamil's armed struggle. Towards the conclusion, the United Nations Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, popularly known as UNCAT, is in line with the concerns of the Universal Declarations of Human Rights, also known as UDHR 1948. Let us conclude with the spirit of UDHR Article 5, which says, I quote, "No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment."